Okay, so this section is on the intellectual property plan for the artist's business plan. Now, if you were working with me on your artist development plan, we talked a few things that involve intellectual property. And in this part of your business plan, you're going to incorporate all three of those. So it should be fairly simple for you since you've completed your artist development plan. Once again, the artist development plan is for the artist, where your artist business plan, although it's also for the artist, it also may be for collaborators or people that want to invest in the artist, people that want to help the artist or do business with the artist. So there's other people reading the artist business plan and not really so many reading the artist development plan. So although we've completed the artist development plan, and you may think this is redundant by having some of that same information, the reason why we're doing it in both is because of the readership. Okay, so what I would recommend is that when we get these topics about copyrights or content protection, which is part 2 of artist development, or about patents or trademarks, all of that can go into your intellectual property plan accordingly. So some of that you may be able to copy and paste, and other parts of this, since we've kind of enlarged your thinking a little bit as we've gone through this semester, you may be able to rewrite it in a more succinct, better described way than you did when we were just starting off working on the artist development plan. So within the intellectual property plan for the artist, there's lots of things that we can look at, and some of these that I just had mentioned to you about content protection, a trademark, patent, copyrights, and those kind of things all come under the umbrella of intellectual property. The money tree in the music industry is owning and controlling content. Well, how can you control it if you don't protect it? So the intellectual property that you're going to be creating and recording and so forth. So it could be the C-circle copyrights, with making your beats or writing your lyrics or coming up with a good melody. Or it might be your P-circle copyright that might have to do with the recording of those songs. So these are things that you have to think about when you're getting into your intellectual property. And one thing that I would recommend is that whenever you talk about your art or things that you're working with your business plan, that's actually part of intellectual property. I would recommend that you try and get some sort of non-disclosure agreement with anyone that you're going to be working with. And it's not tough. You can just say, hey, I'm sure you guys have been through intellectual property agreement or non-disclosure agreements. And therefore, I would like to include that with this. So any trade secrets that you might have, this especially is true when you're talking about co-writing with another individual. Typically, a songwriter, if it's a co-writing agreement, typically one of those co-writers has an idea to bring to the table in the first place. Maybe it's a chord progression, maybe it's a lyric, maybe it's a title, but somebody has something to begin the co-writing process with. So if that's the case, when you bring on a co-writer, which I encourage all of you to do regularly, is to co-write, is to have some sort of non-disclosure agreement to protect your intellectual property. Okay, so these are just some of the things that you're going to need to think about as you're developing your intellectual property, from the secrets that you have within your business, the agreements that you might have regarding the music law, making sure your licenses are valid, and to avoid infringement on all of your intellectual property that you own or control. Okay, so something to think about with your intellectual property plan. Now, the intellectual property plan is section 12 of your artist business plan, and we've been through starting at the company overview. We've gone into the personnel plan, the products and services plan, marketing plan, customer plan, promotion plan, advertising plan, competition plan, sales plan, and now we're up to the intellectual property plan. And a lot of times these topics and these little ideas that come up with him have to do with a lot of the past plans that we've already come up with. And it will also include things that we're going to talk about in the future, your technology plan and your finance plan. So these are just some ideas that come along with while you're putting together your intellectual property plan. Okay, so it takes a little bit more than just saying, hey, I need one. You got to be able to put together the details of what it is that you need. So yes, we all need one, and the last thing you want to do to put in your artist business plan says, okay, well, we'll need an intellectual property plan and then move on. No, I would recommend that you think through this with your trademarks, your registered trademarks, or your copyrights, or your service marks, or your recordings. All of those have to be protected, and it's all going to be part of your intellectual property plan of where we're going with this. So there's lots of different ways to look at it. There's types of intellectual property, including copyrights, trade secrets, right of publicity, patents and trademarks. All of those have something to do with what you're owning and controlling. So when we talk about copyrights, for example, we'll be talking about original works, videos, books, poems, songs, those kind of things. Trade secrets might be your business plan or your attack on your marketing or how you're going to do your promotion. Your right of publicity might be the artist's photograph or signature or persona that is used. Maybe if they have a really unique voice that needs to be protected as well, and you just don't want anybody using it. So these are things that have to be thought about. Your patents, maybe not so much in this industry, but certainly possible, especially since many of you that are listening are into the recording arts. Those engineers certainly come up with new products all the time. And if that's the case, you might really seriously be looking at some patents. And it's certainly an option that you need to consider. So when you look over the patent part of it, I would recommend that you think about your engineering and maybe producing, but mostly engineering aspect of this industry. And then certainly trademarks, and we'll get more into this in just a few seconds, about the company logo, especially the logo. And once again, some artists do trademark their signature. So something to consider along with the types of intellectual properties there are. There's quite a few of them, okay? So what we're going to be talking about is content clearances, content development, copyrights, digital rights management, discography, patents, registration of intellectual property, sound exchange, and trademarks. So let's take a look at the three most common things to start with: copyrights, patent, and trademarks. And all three of these were addressed in your artist development plan. So once again, you may be able to, and the word may is important to think about, you may be able to make this easy for yourself by just going into your artist development plan, copying the information, and putting it over here into your artist business plan under the right topic, okay? So when we talk about copyrights, once again, and I know this is a rehash, but it's a good idea, your copyrights include anything that's in tangible form, something that you can touch, and tangible form. So this would include music and lyrics and beats and books and handouts and lots of different things that have to do with intellectual property along the lines of creative works. Okay. Now, once you get those creative works, then you put them into a piece of circle copyright with a recording. So, something to consider. Trademarks, once again, you start off with a trademark with a TM. And once it's registered trademark, you end up with the circle R. Okay. And a trademark most likely is going to be the artist's logo and or maybe their signature, or maybe even some products that they come up with on their own that they're going to trademark. So there's lots of things to do with trademark to make that work, and you use them everywhere. So you got to be able to protect your mark, and the best way to do that is with a registered trademark. As far as your patents go, once again, this really is going to come down to those engineers that are in the music industry trying to come up with a new idea, maybe electronic idea that they can work with. I do know somebody in the RAT program that actually came up with the idea of those greeting cards that when you open them, they sing a song to you. Maybe you've seen that. That was a good patent. They ended up selling that patent to Hallmark for $1 million. And that worked out real well for them. So something that you might want to consider when you're doing your electronics, especially as an engineer, is to maybe come up with a new idea that can be patented. And then filing for that with the same office as trademarks, the USPTO, that's United States Patent and Trademark Office. And you can find that at uspto.gov. Okay. So that's where those will come through. And then when we talk about content clearances, this is when you're going to take your intellectual property and be able to clear it in two different ways. One way is that you're going to be clearing it for others to use your material. That means you're going to be granting them a license to do so. The other way is when you're using somebody else's material and you want to include it within your own art or the artist's art. And that typically would be a copyright. And this typically also happens with the sampling world. Okay, so when artists are doing sampling, they're going to have a clearance of the copyright to legally use somebody else's material. So when you're going to be writing about your content clearances, I'd like you to think about it from both perspectives on which material you're going to be using that from somebody else, as well as, and probably most importantly, the material that you're going to have other people use and then pay you a fee or royalty for the use of that content. We can't forget Sound Exchange, and this works really well for record labels and for musicians and for songwriters. Okay, so if you haven't joined Sound Exchange, or if the artist that you're representing has not joined Sound Exchange, I would highly recommend that you do. It's free. And soundexchange.com, I believe, is the best way to reach them. Go through the process, and that way you can join. Now, Sound Exchange pays for non-interactive streaming audio only. Non-interactive streaming audio. Okay? So if you, as a musician, have a recording that you're on, and it is being played on non-interactive streaming audio, like maybe through Pandora, or maybe even Spotify, depending, then there's a chance that you can get paid a royalty every time that song is performed. And so now not only do songwriters make money, but this is finally a chance that musicians who are on the recordings can start making money from the interweb or internet of sound. So definitely be joining a sound exchange. And then for those of you who are starting your own record label, which we'll talk about in the record label class, you'll need to also join Sound Exchange, not only for the artist, but also for the record label. Okay, because typically, who owns the recordings? A record label, not the artist, typically. Okay, so that means that the money comes from Sound Exchange and pays the record label. Now, the musicians who are on the recording probably have a deal with the record label that they will get paid on anything sold. And so that way, when something is sold, Sound Exchange pays the money to the record label because there was a sale, which is non-interactive streaming audio. And then the record label takes the money and divides it up with the other royalties that are on that agreement. So if you are in control of your own record label, as well as a songwriter on those tunes and recordings, you need to join as a songwriter and you need to join as a record label. Okay, now this is intellectual property. That means it's a good idea for the artist to list here. This is where you're going to get into your PROs, your performing rights organizations. And if you haven't done this already, I don't know what you're waiting for. ASCAP, BMI, and CSAC are the three main performing rights organizations in the United States. Look them all up, investigate them, find out which ones you're most comfortable with, or just kind of get the vibe on which one's going to be best for you, and then look to see about joining one of these. Okay? And I'd do it now. There's no reason why you can't join one of these organizations right now. And that way you'll have it down. ASCAP is free. BMI, I think, is $50. And CSAC, you have to be invited. But I did explain to you about the various topics of this when we talked about the artist development plan. And once again, go back to your artist development plan, make it easier on yourself, copy and paste it over here about which of these organizations the artist is a member. Okay. One thing to consider is that sometimes the artist might include multiple songwriters that are within the artist, especially if it's a band. And those songwriters might join different PROs. And if that's the case, list it here in your artist business plan that songwriter A is a member of ASCAP, for example. Songwriter B is a member of BMI. Maybe songwriter C is a member of CSAC. I mean, I don't know, but list it out here with where you're going. And then certainly all those songwriters should also be a member of Sound Exchange. Okay. So content development was addressed in section 1 of your artist development plan. Hopefully, you've also included it in section 5 of your products and services plan. And also, if you're working on your own record label, which some of you are, then it's also in section 5 of your record label business plan. Okay, so content development would go under products and services as well. One of the other things is your discography. This would also be identified in your products and services plan, but it's also intellectual property. And once again, if you're working on record label plan, it's in section 5 of that. But this would be your catalog of singles, instrumentals, albums, demos, videos, all the things that are put together by the artist or the record label as far as content goes for others to pay attention to. So something you might want to consider with this. And you might want to look at your song catalog spreadsheet that I provided a few classes ago. And that way you can, on there, there's a column about demos being completed or not completed, and just kind of go back to your catalog to fill some of those things in. Okay, and then how are you going to manage your digital rights? Okay, so this is basically a collection of techniques used by copyright holders to limit access to and use digital content. For example, Apple's Fair Play or Microsoft Windows Media DRM of where you're going with this. So you've got to be able to manage your rights. And some people and many artists do this. They give away their music. Okay, that's fine. There are no digital rights management to worry about. But if you're not giving it away, how are you protecting it? If you put it out on CD, are you protecting it, for example, that it can't be copied? I don't know. This is something that you're going to need to look at, consider what you're doing, and then put it into this section of your plan. Now, the registration of your intellectual property basically comes from two different offices within the United States. The Library of Congress does your copyrights, and the United States Patent and Trademark Office obviously do your patents and trademarks. So you're going to need to deal with both of these organizations, and this should go into your plan. You only probably need to deal with the trademark office once, and that's once your trademark is completed. I mean, your mark is completed, your logo, and then filing for that with the USPTO. You might not ever need to use the patent office. We've talked about that just a few minutes ago. But most likely, each artist is going to be using the Copyright Office on a regular basis, especially and really only if the artist is a songwriter. And I've told you guys the importance of developing your songwriting. So if you haven't done that already, I would recommend that you start writing some lyrics or you start writing down some tunes. And if you don't know how to do that, you might want to take a class in songwriting or in scoring or in some way that you can lay down this information so that you can file it with the U.S. Copyright Office once the work is completed. Okay, but those are the two offices that you're going to need for the registration of your intellectual property. Okay, that's it for the intellectual property plan. Are there